Welcome to the Las Vegas Review-Journal Judicial Primary Election Conversation. Here is your host, Steve Sebelius.
Welcome to the Review-Journal's Judicial Primary Conversation. Tonight we'll be speaking with Nevada Supreme Court Chief Justice Kristina Pickering. The Review-Journal asked the two other candidates in this race to participate, but they declined. Tonight's conversation is being conducted using Zoom because of the coronavirus and the governor's admonition to have social distancing at least until the end of the month. So I'd like to welcome to the conversation the Chief Justice of the Supreme Court, Kristina Pickering. Thanks for being here with us tonight.
Thank you so much for hosting this. I appreciate it.
The first question, a very basic one. Tell us your judicial philosophy in just plain English.
Sure. Judges decide cases according to law. The law is set by the Constitution, the legislature, and case precedent. It doesn't matter what I personally think as a matter of policy the law ought to be. It's what it is. And everyone who comes to court is entitled to have that law applied fairly and even-handedly to them. I work really hard to do that and to be neutral and well-prepared and decide cases on the record presented and the law that applies to it.
In your case, though, in addition to applying the law, you're a court of terminal jurisdiction. You also make the law. You interpret the law, interpret the Nevada Constitution, and as we know from Marbury versus Madison, it's emphatically the province and duty of the judicial department to say what the law is. So, in your case, you're not only interpreting, you're also giving guidance to lower courts.
Absolutely. Nevada Supreme Court is the court of last resort in this state, and with rare exception of a case that gets reviewed by the United States Supreme Court, we're the last word. And our cases cut across all areas of law affecting Nevadans in their day-to-day lives, from family law to water law, to civil law, to criminal law, to commercial law, to administrative agency law, public records law, and everything in between. And so we interpret those laws, those statutes in the cases and constitutional provisions they implicate, to be sure.
Given that lower courts rely on the Nevada Supreme Court for precedence, do you think the Supreme Court produces enough case law for the lower courts to rely on? And how can the court issue more of those published opinions for those lower courts to guide them?
Well, there's two parts to the answer to that question. First, when I got on the court, the so-called unpublished dispositions, which are publicly available but called unpublished, were not citable in the district courts. And I promulgated a rule change so that they can be cited. And I feel that's an essential piece of holding a court accountable. If you have a case, similar facts, similar legal, you're entitled to say, wait a minute, the last case that you had with those same facts and those same legal issues, you decided this way. I want you to decide my case that same way. We put in that the rule now is amended so that they are all citable, all of our dispositions, whether they're deemed published opinions or not. But you're correct. The published opinions establish mandatory precedent, which is to say the district courts must follow it. The unpublished dispositions, while they're citable, are not mandatory, but only as persuasive precedent. Nonetheless, they're all available. They're on the public website, and they are citable by everybody. And we decide on average 1,500 to 2,000 cases a year. But yes, we should publish more opinions. I wish we had world enough and time.
Yeah, it's quite a workload in any event, that number of opinions. You serve on the Access to Justice Commission, and it may not surprise you that many of the judges that we've interviewed during these debates have said that they believe that there is a justice gap. What more needs to happen in Nevada to ensure that more Nevadans have access to justice in the state?
Yeah, I'm co-chair on that, and I've worked hard sitting on the Nevada Supreme Court to promote access to justice. I founded the Nevada Appellate Pro Bono Project in 2013 with the help of Ann Traum at UNLV Boyd and Barbara Buckley and others. And we have instituted that. It's been really successful. It's very hard when you have a case with a self-represented person on one side of the caption and a represented person on the other, especially in the appellate arena. So that's a small improvement. But you're right, the 2018 study of Nevadans' legal needs shows a gap. We're doing what we can. I think with the COVID crisis and the economic turmoil that we'll be facing, it's going to be all the more challenging, particularly when some of the stay orders that Governor Sisolak has imposed are lifted, and you find people going to court without the money and the representation that they need. I will say, though, that across the state, legal aid providers have made great strides. Last year, our Legal Aid Center of Southern Nevada was recognized for achieving a first. Every foster child had a lawyer to represent them in their court proceeding. And that's cause for celebration, even though the need remains great.
Absolutely, absolutely. Well, we're going to take a short break, and we will be back in just a moment with more questions for Nevada Supreme Court Chief Justice Kristina Pickering right after this. Stay with us. Welcome back to our Judicial Primary conversation. We're speaking with Nevada Supreme Court Chief Justice Kristina Pickering. She's running for re-election for a third term in Seat B. Nevadans have rejected at least twice proposals to appoint rather than elect judges. Do you think there would be a noticeable difference in the judiciary if judges were appointed and then stood in retention elections as opposed to having to be elected every 6 years?
I'm not sure that there would be. There's a lot of different schools of thought on that, but many of our judges do go through merit selection and are appointed, and then they still stand for election, albeit against an opponent. The question is not only how you pick them, but how do you get rid of them when they're not doing a good job? And the federal government, interestingly, it's considered a life tenure, but that was a big point of debate among the founders, is what do you do with a judge that's not doing well? And I think we focus on the front end and not the back end. And perhaps there needs to be a wider dialogue on that.
Do you, looking back over, you've been in office now for 2 terms, that's 12 years, judges are elected to 6-year terms. Is there one particular ruling, one particular case that you're especially proud of, that you think the court really did an excellent job with that particular case that you can tell us about?
There are many that I've counted as important. There was one that was very important to me because on multiple levels. It came into my office on a 3-judge panel, which is to say it was not rated for all 7 to sit and hear it. And it was an appeal from the denial of a 3rd petition for habeas corpus by a man named Marla Berry. And when I got the case, I started reading it, and it's easy as a Supreme Court justice you see so many different cases and they fall into categories. But as I read this case, he had been denied an evidentiary hearing on his claim that he was actually innocent of the crime that he had been convicted of when he was 19 years old. And as I read through that case and the record, I became convinced that yes, he had a legitimate actual innocence claim. And there were some very technical legal issues that go along with that, and I won't go down that rabbit hole with you, but I talked to my law clerk about it, and she was coming to the same realization as I almost simultaneously, and the 2 of us worked on that case together. It was orally argued, and I authored the opinion and handed it down on December 24th, 2015. we reversed and remanded for an evidentiary hearing on whether he was in fact actually innocent. And the proof that was put forward on that point was really compelling. We don't have time to go through all of that here. But following remand, I kept track of the case, and it turned out that the district attorney's office re-investigated the entire case and the new witnesses and evidence his lawyers had found, and they exonerated him. He was released. He was released, though, from High Desert Prison and dropped off in North Las Vegas. And he had nothing to reintroduce himself to society. So had he been paroled, he would have had the transitional services that go with that. But because he was exonerated, that was not in place. So I worked with my extern that summer on what do other states do in that situation. And she came up with a really wonderful study that she did herself that showed that Nevada was just one of 15 states that had nothing in place for that. So the 2019 legislature, and she came home from college to testify in support of that legislation, unanimously passed exoneree reparation legislation for Nevada. It's a small segment of the society, but I'm a fervent believer that ours is one of the best dispute resolution systems in the world. But when we get it wrong, we owe an obligation to fix it. And I feel like in that case that happened.
Yeah, and you don't really think about that. We hear a lot about the cases where people are exonerated, but not a lot about what happens to them after that. So that's kind of an interesting perspective. Well, unfortunately, we are out of time for this conversation, but I'd like to thank Kristina Pickering. She's the Chief Justice of the Nevada Supreme Court, for joining us for this judicial conversation. Remind you that you can stay up to date on all the political races in 2020 on our website at reviewjournal.com. For the Las Vegas Review-Journal, I'm Steve Sebelius. Thanks for watching, and thanks to Justice Pickering for participating tonight.